This program is brought to you by the Georgia Neurosurgical Institute. For over 50 years, rendering neurosurgical care to patients of all social conditions, treating complicated problems involving the brain, spine, spinal cord, and peripheral nerves, endeavoring to encourage quality care, medical research, innovation, and education on a local, national, and international basis.
Good evening. My name is Joe Sam Robinson. It's my pleasure to have with us tonight once again the redoubtable Mr. Buck Melton, Dr. Buck Melton, Professor Buck Melton. Welcome, Buck.
Glad to be here.
Now, Buck, I have said I'm a little nervous about the presidential contest, and I'm equivocating. What about you? Have you thought about putting your hat in the ring for the different issues here? Have you considered that?
Well, to quote Major Winchester in a slightly different context, not even at gunpoint.
Oh, okay. So, all right. Well, I guess the American
It's
people
all on
are
you.
left with their.
It's all on you.
Well, we'll have to just several candidates out
And I cannot think of a better year in which.
Yeah, that's right. This is the time
So,
for a novice. Well, I think Donald Trump just sort of came out of the blue, did he not? Well, a little joking there.
Yes.
One of the things that's occurred recently is the member of the Supreme Court, Ruth Bader Ginsburg, has pretty overtly criticized one of the presidential candidates, which is kind of an unprecedented thing. Can you make a comment on that? Can you opine on this?
Yes, I am very upset at this. For several reasons. The idea is that judges are supposed to be impartial. They are the age-old common law statement that no man should be a judge in his own cause. And if you inject yourself into a cause, then according to that maxim, you can't be a judge in it anymore. And the abandon with which Justice Ginsburg has thrown herself into one of the oddest and most fractious presidential elections in recent American history is just mind-boggling. Not only did she say some things, she then doubled down, and 3 times in the past week she has made extremely critical comments of Donald Trump, naming him by name. And to go on the record, if she had said these things of Hillary Clinton or said something similar of Hillary Clinton, I would be equally upset, or at least I would hope that I'd be equally upset.
Well, now, people on the right and the left have criticized this. I mean, plenty of people that are we consider pretty far to the left have thought, well, this is just an utterly inappropriate thing. I can't think of much praise she's garnered from doing this. Is that a fair statement?
Yes. Well, the New York Times, which is the liberal newspaper of record, has gone after her and surprise, surprise, has actually sided with Donald Trump on this, and many other less liberal publications and commentators certainly have. Some people have tried to defend her by saying that justices have gotten involved in the political process before, and that is true. For instance, Charles Evans Hughes, who was a Supreme Court justice, actually ran for president in 1916, got the nomination, and only after he got nominated did he resign from the bench. You had Thurgood Marshall in 1987 criticize Ronald Reagan's, sitting president Ronald Reagan's report card on race relations. Abe Fortas, who continued as a Supreme Court justice to offer counsel to Lyndon B. Johnson in the 1960s. I could give other examples, but the difference is political involvement at that level is different from injecting oneself into an actual campaign, and that is what has happened here. So I think that what Ginsburg has done goes far, far beyond what you have seen justices do in other contexts.
Now, is there a reason for these restrictions? Maybe we can discuss that. And there are other classes of federal employees that have, at least there's some idea their freedom of speech on these issues might be limited. The idea of Army officers, naval officers, and the other officers, they have some kind of restriction, do they not? At least overtly. Can you opine on that?
Yes, well, certainly senior Army officers, senior officers in the military, I think as a matter of tradition, at least in generations before this one, would refrain from voting as deference to the idea of civilian control of the military. I should be up on any federal laws in that regard, but I'm not. They've certainly taken a loyalty oath to the Constitution and to the Commander-in-Chief and the chain of command. In terms of civilian federal employees, of course, you have the Hatch Act, which has been around for not quite 100 years, and that limits political involvement and tries to call for political neutrality. There are, in fact, both federal statutes and judicial codes of conduct that are aimed directly at the judiciary. You have a federal law, it's in Title 28 of the United States Code, that requires all judges to maintain impartiality and to recuse themselves if they have some sort of interest or if somehow involved themselves in the case to an unreasonable degree. And I think that everybody here would say that Ruth Bader Ginsburg is being unreasonable in her injection of herself and her views into the campaign. You've also got the Federal Code of Judicial Conduct, which oddly enough does not apply to the Supreme Court. It applies to all lower federal courts, courts that are the creation of Congress. And very clearly in that Code of Judicial Conduct, you would see activities like Ruth Bader Ginsburg has engaged in would be forbidden. In other words, if she were a judge on the D.C. Court of Appeals, the Court of Appeals for the District of Columbia Circuit, and had done this, she could be disciplined for it. As a Supreme Court justice, she cannot.
Yes. Well, all right. So we've been through some of the some comments about the line that Justice Ginsburg crossed.
Yes.
I mean, imagining. I mean, we'll for the moment we'll just let it pass as to the respective merits of the presidential candidates. But assuming or imagining that Donald Trump became president, I mean, would that cause some kind of difficulties on any kind of case involving the federal government that came before the Supreme Court? Would she have to recuse herself? And indeed, if a judge has a very obvious prejudice on any issue, it's sort of up to the judge to say, well, I feel so compromised that I can't participate in this decision. It sort of scouts honor on the subject. Is that, I mean, what would happen? I mean, let's suppose a judge has displayed a very obvious prejudice on any issue. And it's well known the person, I don't know, is, let's say, a pro-gun control person, is in the IRA and is loaded with, I don't know what, guns of all types and marches in parades. And
Yes.
then the issue comes before the judge. And maybe he's even made public defense of gun rights, and a case comes before the judge, and the judge passes judgment on that particular issue. I mean, what can be done, and can the public be protected, which I'm getting into is very obvious prejudice.
Yes.
So the reason this is disturbing is the judge is displaying a very obvious bias in a particular direction, and it's obvious that if perchance Donald Trump were elected president, all sorts of government decisions that he might espouse would come before the Supreme Court. Would Justice Ginsburg, what would happen? I mean, she's made these
Yes.
pretty strong comments.
Yes, well, anything in which Trump, a hypothetical President Trump, had somehow been involved in signing the legislation, making signing statements, proposing the legislation, publicly backing the legislation, I think she should have to recuse herself. And you gave, interestingly enough, the hypothetical of a gun-toting NRA card-carrying member.
Right.
When Justice Ginsburg was nominated, I believe in 1993, an issue arose because she was a card-carrying member of the American Civil Liberties Union.
Yes.
So and the ACLU obviously takes some positions that are controversial, and so the question came up there. So it's not at all hypothetical. I would say that she should have to recuse herself. I think an argument could even possibly be made for the fact that if Hillary Clinton were elected, she would have to recuse herself in similar circumstances because she showed partisanship. You can say if she's against Trump, she's
Right,
for
yes,
Clinton.
yes.
It may be a stretch. But ultimately, according to the law and Supreme Court tradition, that's up to the individual justice. Several justices on the right, for instance, Justice Scalia and Justice Thomas, have occasionally drawn fire in recent years for not recusing themselves when the left believed that they should. But even though they had made certain public comments, general public comments that showed a certain political allegiance or an economic stake in the outcome of a case, I think you'd be hard-pressed to find anything this blatant. So the question is, will she recuse herself? Well, that seems to be up to her.
Is that true in general among judicial appointments or people that have that responsibility? Is there any way that the public, if I could say this, could be protected from obvious bias on the part of a judge? So, I mean, if you could imagine you were, I don't know, you were on death row and you had some claim to want to be spared that. And it went before a judge that had many times just said, I totally, if this ever came before me, I would throw it in the trash can. I mean, that's obvious a case where a person with that degree of obvious bias should not participate in such a decision. And well, what do we do? How does the public protect itself from obvious publicly stated biases of the judicial branch that have such an important responsibility? That's a big deal, isn't it?
Yes. Well, there are several layers of safeguards in place. For instance, the very idea that we have two different court systems, two levels of court system in this country. Each state has its own court system, and then you have the federal court system. And one of the original ideas behind that was diversity of citizenship, that if I am a citizen of Tennessee and you're a citizen of Florida, and we have an altercation over property in Georgia, then, or perhaps make it in Florida, and I have to sue you in your home state, might the judge in a Florida court somehow be biased in your favor? And the idea is it could be removed to a federal court, or the suit could be brought from the beginning in a federal court, and the federal judge would be a more neutral party. So you can always say, and there are a lot of, for instance, in criminal law, habeas corpus proceedings, that under the state courts you didn't get a fair trial and your federal constitutional rights were violated. If, on the other hand, the problem is with a federal court, you do have the judicial conferences, which look over the shoulders of federal judges. You have the federal statute that I mentioned earlier, and the Code of Judicial Conduct. And the Code of Judicial Conduct applies to all courts except the Supreme Court. Further, if you've got a case when you've got a judge who you believe is biased, you can file, as a party through your attorney, you can file a motion requesting / demanding that the judge recuse himself. Interestingly enough, my late father, back in the 1970s, there was a case involving, I believe, the BP building. It's not known as that anymore, but it's the 1970s style building that's out on Eisenhower Parkway. It's on the corner, I believe, of Eisenhower and Log Cabin Road. And there was litigation regarding that building. And my late father, while representing Charles Jones Enterprises, filed a motion requesting that the judge recuse himself.
Oh, you can actually request the judge.
Yes.
Yes.
Now, the judge doesn't have to honor that.
Right.
In that case, I think the judge transferred the case to another district, but then a man managed to, if memory serves, got himself appointed to sit on the case in that district.
Oh, okay.
And so the case went on that issue to the Federal Court of Appeals, which told that judge, you can't sit on this case.
Yes, yes.
But who can tell the Supreme Court justice that?
Well, I guess the point I'm getting sort of peripherally into, or sort of surreptitiously into, is the idea, at least a suspicion exists, that the judges no longer interpret law, but actually make law. And I mean, we've discussed a number of situations where it appears the Supreme Court is basically really just saying this is the way America should be. We've also commented as their views or their backgrounds are often fairly restrictive these days. And they're saying, well, this is what the world should be like, and this is my bias. And actually, law is I'm stating this pretty intensely, and maybe it's a little too far, But the idea is that law is pretty secondary to what's going on here, and I'm going to put my biases out there, and I'm going to try and make the world better. I'm not going to wickedly do anything, but this is my view of what a good world would be like, and if the law doesn't comport with it, just too bad. And now we have a justice that is saying a pretty extreme viewpoint, and just to continue on it, obviously these biases are, I'm going to use the word biases, are so powerful that judges tend to vote on issues in a known way. So, I mean, I know you're a student of the court. So this is a very, very powerful branch. It has this incredible responsibility and power that the citizens of the country have given it. The Constitution has mandated tremendous powers for it. We have a 4-4 situation. And can the American people expect justice from a court that might be somewhat, let's say, making new law, to phrase it politely? They make new law, and they're very biased in one direction or another, and they always take an opinion that you could say would be an obvious opinion of the Democratic establishment, or on contrary-wise, on the Republican establishment. And so it almost doesn't matter whatever the issue is. It just depends on the biases of the court.
Yes.
And what can we do about that? And does the institution need a big re-examination?
Yes. Well, if the justices are going to behave like this, yes, it certainly needs re-examination. That the greatest strength of an unelected judiciary is also its greatest weakness. And that strength/weakness is that it is not a democratic organization. It is not responsible to the people. It's a strength in the sense that you don't want judges listening to the voters. You want judges looking at what the law commands. The weakness is that if the judges who are not elected don't look at the law, and instead they look at their own predilections, their own ideas of the way things ought to be, how do you rein them in? And this is a classic example of that. That I think what Ginsburg was trying to do. She's old. She is, I'm sure, clear in her own mind that she is either going to die or retire sometime in the not too distant future. She is 83 years old. And she has decided that Trump is such a horrific candidate that she is going to stake her entire reputation on trying to sway the election by denouncing him. Either she's doing that or she's saying it to make herself feel good. I'll give her the benefit of a doubt and say that she's trying to do what she thinks best for the Republic. I think that that's going to backfire horribly. It already has backfired horribly. And it's going to do two things. It's going to greatly diminish her own reputation in the long run, her legacy for posterity. And even worse, it's going to tarnish the reputation of the institution of the Supreme Court, which is already, as you note, is strongly suspected of making law rather than interpreting it. And I just don't see anything good coming out of this.
Yes. Well, now you broach the subject of some consequence. And that is just to discuss her general state of health. She is 83 years old, and I'll be charitable to Judge Ginsburg, obviously a very special person with great merit and intelligence and all sorts of good qualities. But she is 83 years old, and she's a pancreatic cancer survivor. I think she's in obvious and frail health. That's an obvious story. What one doesn't know in these circumstances is just exactly what's going on with cognition on a very elderly, frail judge. What's the impact of cognition? Are these justices in these very important situations, I'd say as important as an airplane pilot or a neurosurgeon, dare I say, as far as their ability to be on top of their subject and to be ready for whatever, and the public would require substantial intellectual agility and energy. There's no age requirement here. Additionally, one of the things that happens, just to ask this question, there are many kinds of medications that a frail 83-year-old person might be taking that could cause some, at least altered intellectual agility. I mean, and for better or worse. And I mean, I'll be generous on the subject. But what I'm getting into is these are very elderly judges. Is the public being served by keeping a judge on for a long period of time like this? And as I understand it, the statute in Georgia, maybe it's apocryphal, but I think when you're 75, you have to think of at least retire. Your pension gets diminished or something like that. There's no obvious. You get a little punishment if you stay on.
I think you'd have to check with our mutual friend Steve Dillard on that.
Sure.
Who can tell you how judicial administration works in Georgia.
I believe there's a gentle persuasion.
Yes.
And so the question,
status.
yeah, right. The question is, there was a very aged Supreme Court with very complicated issues coming before it. When judges in frail health, a person that would be frail enough that if this were your own attorney, if Ruth Gator Ginsburg was your attorney on some kind of case, you might respect the person, but you might wonder how well such a person would do in a challenging intellectual situation. So what I'm getting into, is there some kind of reasonable health test or some kind of at least age issue that might be appropriate, and would the Constitution have to be amended to do that? And my third comment is, what is the general situation with federal judges that takes senior status? I believe it's financially advantageous, or there's some at least reasons to consider it, and maybe it's in the public interest for that to happen.
Yes. Well, first of all, I think you bring up the very important point. This document was written 200 years ago, and health sciences have increased dramatically since then, have increased dramatically just in the past 50 to 75 years. The original idea was that we put our older, wiser members of society on the bench. There's no minimum age requirement, but certainly that's the idea. And yes, wisdom as opposed to knowledge. It's learned experience, and that's great. But we're running into a situation now where wisdom decays and becomes, what's the word, senescence, senility, and that's a consideration. In 1937, when Franklin D. Roosevelt was inaugurated and began his second term, he was opposed to the obstructionist policies of the Supreme Court that the New Deal had proposed law after law, had passed law after law, and 5 justices on the 9-man Supreme Court, in terms of judicial philosophy, believed that those laws were unsupportable under the Constitution. And so Roosevelt proposed essentially a packing of the court. And he denied that what he was trying to do is pack the court, but he was very emphatic that you have these 9 old men, most of whom were over 70.
Yes.
You're 70, right?
Yes.
Just checking.
Still just a pup, may I say. Still just a pup, but I'll hit the tennis back at some baseball back.
I'm sure he'll get me. But yes, so Roosevelt would have called you an old man, past your prime, out of touch, and to lighten your workload, Roosevelt was going to say for every justice over the age of 70, we can nominate and appoint an additional justice.
Yes.
There was a huge backlash on that. Back when old was considered 70.
Yes.
So bring that forward a few years. We can keep the body going, but what happens to the central nervous system? What happens to the brain at age 80, at age 90?
Or dare I say,
even a good brain.
Dare I say 70? Yes. And so I'm making a slight joke here, not altogether.
You can get me at 53.
No. I mean, so there. I guess there's a decline in intellectual agility as one gets older. It's going down, and there's also another line, as you spoke about, of wisdom, getting a little older. As you get older, the sense of restraint, judgment, as in a judge. I mean, obviously, an older judge does have its merit. A person that's seen many, many different kinds of cases might be wise. So I take that point. I mean, I'd like to make the point is that the ability to pick up new skills declines. There are different ways to look at cognition in the brain, different kinds of studies, and in general, there's a substantial decline as one ages. I mean, the mass of the brain decreases. Lots of tests out there. Lots of things occur. And I guess what many people, I mean, you could make a case. Many people have surprisingly preserved cognition, if I phrase it that way, I won't make any more joke about it. But on the other hand, there are cases where particularly a person in ill health or different reasons that happen, different studies that can undertake this, you can say, well, this airplane pilot might be 70 and can still fly the plane with great agility. And another 70-year-old may not, and it's particularly an issue when a person has had catastrophic health situation where all sorts of things happen, disturbed sleep-wake cycles, different kinds of pain meds, different kinds of stresses that one goes through, changes in neurotransmitters. I guess what I'm getting into is there is a point where senility does start to occur, or involutional melancholia occurs, and senility appears. And there are different kinds of, even dementia can happen. So what I'm getting into is this, just to sell the ship. Is this unusual statement on, we speculate as to why Justice Ginsburg might have done this, and a noble thing would be, this is, and I don't dismiss this as a possibility. You know, I care about this country, I've lived here, it's a sacred thing to me. I see a horrible person appearing. And I won't be long for this world, as you suggested. Maybe the doctors have told me I have 6 months to go or whatever. Or maybe I won't be in the next, I know my health is fragile enough that I won't be here in 6 months or 8 months. And before I go, I want to make this one great, I guess, statement for the American people. I want to try as hard as I can to, I've devoted myself to the country, and my last thing is to do this, to make this statement. Maybe that's the case, maybe. But the question would be, an age requirement is. You mentioned Roosevelt. Would that be useful? I mean, or some kind of check, just in general, of people in positions of responsibility, or is that too much of I guess, an affront to their dignity?
Yes. Well, I'd answer the last question first. Instead of going just by statistical models, general models, after age X you start to decline. And to point the gun back at myself here, at age 53 I'm already quite cognizant of the fact that in some regards I am, my mental prowess is slipping and has been for a few years.
Bucky, if I could say this, you're just a pup. I'll throw this out here.
Well, then I don't want to think what's going to happen over the next few decades. So what about specifically neurological tests? Require a justice after the age of X to undergo various cognition exams, neurological exams. In a larger sense, given what Ginsburg has done, this was not an isolated event, and she seems at pains to point out that it wasn't a slip of the lip, that it wasn't a senior moment. That she made the statement and then she followed up over the next several days with not one but two additional statements, calling Trump a faker, for instance. And so it seemed to me that if there's a problem there, it's a systemic problem or a systematic problem. But if she really believes that she needs, in the time remaining to her, to make some sort of stand, to make some sort of principle declaration, then she should have resigned her position and then done it. I think that she would have come off looking a lot better, that she would have put her money where her mouth was. It would have, the statement would have been stronger. As it is, she just gives the impression that she's trading on whatever goodwill the court has got left, which I would say is precious little at this point based on what the court's been doing the last 20 or 30 years.
Well, I mean, we've had an interesting discussion on an important issue here. The country really is at a watershed moment in many ways. The choices are so extreme in each candidate. One could say that it's a very unusual election, yes, considering the intensity of the differences, the whole polarization of the country.
Well, my last word on this, if I can jump in for a minute, is it has been quite a roller coaster. We've seen many things to bother the average American that gives us a sense the wheels are coming off. Just in this past week especially, I would say during this entire past year, the thing that has demoralized me the most is what Ruth Bader Ginsburg has done during the past week.
Well, that's a pretty strong statement.
Yes,
and on that note, and it's very strong. Yeah. And on that note, Bucky, thank you for being here. We'll talk some more. Thank you.
This program is brought to you by the Georgia Neurosurgical Institute. For over 50 years, rendering neurosurgical care to patients of all social conditions, treating complicated problems involving the brain, spine, spinal cord, and peripheral nerves, endeavoring to encourage quality care, medical research, innovation, and education on a local, national, and international basis.